Hello, everyone. Welcome to the next installment of our clown parade that we call it broadcast. Welcome to another episode of the Justice Revolution. I'm your host, James the Patriot. I have with me my partners in crime. There's no pun intended with that one. Erica from the beautiful state of Indiana, and my producer and co-host, Justice, just to the north of me in about 15 feet of snow.
Yeah.
Did you unbury yourself?
Yes. Yeah.
That's insane.
We have all the equipment, so yeah.
So you have like a massive front-end loader tractor to dig yourself out of that?
No, we do. We have a 1967 CJ Jeep named the General.
Oh, there you go.
Painted army green with a big star on the front, and can push snow straight up a tree. Amazing.
I like that.
Yep. And we have a snow blower with tracks on it. So
nice.
Yeah.
How about you, Erica? How's life in your neck of the woods?
It's interesting. My youngest son and I, we were just studying today about weather modification.
Oh, you gotta be kidding me. That's hilarious.
Yeah, HARP and DARPA, they've been pretty busy. They're working on some projects. I don't know if what we're seeing is part of that.
Wow.
I saw them cutting down the harp field in Brazil, the harp plant, whatever you want to call it. I'm going to switch cameras here. I'll be right back.
No, you're good. You're good. Well, that was weird.
Maybe.
There we go. Nope, now you're muted. Oh, this is weird.
You muted again.
Yeah, this is very weird. Sorry, folks, we're having some technical difficulties.
Still echoing.
Yeah, you're echoing.
Because you've got both of your mics are on. I think you need to mute one of them.
Yeah.
And, that's weird. Very weird. Anyway, while Justice is trying to figure out those issues there, it looks like it's coming through your. Yeah, it's that one. That's odd. I've never seen that before. But while she's working through that, let's go ahead and move into the meat of the show today. So I wanted to do a follow-up, so to speak, over the last two episodes we did the last couple weeks where we were talking about jurisdiction, how the court gets jurisdiction, the different types of jurisdiction, what they are, so on and so forth. We talked a lot about that. Don't think we need to go into too much more detail there unless we need a quick refresher. I'll leave that to you, Erica, if you want. We can do a quick refresher, or you think we're good? We can move on to the next subject at hand.
Go ahead, move on.
Okay, cool. By the way, Ian, thanks for being here from up north in Canada. I'm glad to see you're here. Etane and C to AZ. I'm assuming that's C to Arizona, but I don't know. Maybe it's just C to AZ. Thanks for being here, you guys. Really appreciate you guys showing up for our live streams. But for those of you who might be catching this broadcast not through a viewing, I will do my best. I'll do a better job of reading what I'm doing. So those of you who might be listening on a podcast or Spotify or Stitcher or something like that, it's sometimes I make the false presumption that you guys can see what I'm doing on my screen. So I want to make sure that we're all in line there. But let's get to our topic today. So we're going to talk about what happens if you get railroaded in one of these administrative courts, and you've been railroaded. You've done everything you're supposed to do, and we can talk about this down the road. But you filed motions to dismiss. You filed motions to dismiss because they don't have jurisdiction. They don't have subject matter jurisdiction. You've put all of that on the record. So what do you do now when the judge just says, "I've got jurisdiction," and he or she issues a judgment against you? Now, if it's one that involves jail time, obviously that's a serious issue. If it's one of the more minor situations, like a traffic ticket or a minor misdemeanor that carries some type of a fine with it, this is going to become in real handy. And on the flip side of it too, this also works in civil cases, civil matters that maybe you were sued civilly and a judgment was issued against you that you didn't know about, or maybe you did know about it and you tried to fight it, but they still issued it against you. But when you look into the record, you find out, well, wait a minute, the moving party never verified any of their claims. There's nobody verifying what their damages were. Nobody had standing to bring this, so the court didn't have jurisdiction. So we're going to talk about what to do there. So there's two different ways you can attack these types of judgments. You can attack them directly, or you can attack them collaterally, meaning you attack them in a different court. So let me pull up my screen. Let me get to where I'm going to go, and I'll show you where it is in law that allows you to attack this directly. And I'll give you my 2 cents on that as to why I'm not a real big fan of that. But let's get on down to where I'm at. Okay. All right, let me share my screen, and we will get moving into the good stuff. Share screen. Right here. Okay. All right. So back to my trusty Cornell Law. Love this website. They've got a great stuff. They got a lot of good stuff here. They can find everything you need. So I have on my screen right now, I have the rules of civil procedure, the federal rules of civil procedure. The majority of the actions that I'm litigating are in federal court, so that's where these rules apply. Now you'll notice down here, Rule 60 talks about relief from a judgment or order. All right. So under this rule, it states that there's a number of things that you can seek relief from a judgment or order. So the first one is corrections on clerical mistakes, oversights, and omissions. That's just kind of that's a really small thing. But the second one talks about grounds for relief from a final judgment, order, or proceeding. And this is what the rule says. On motion and just terms, the court may relieve a party or its legal representative from a final judgment, order, or proceeding for the following reasons. Number 1, mistake, inadvertence, surprise, or excusable neglect. Number 2, newly discovered evidence that with reasonable diligence could not have been discovered in time to move for a new trial. Number 3, fraud. That's a big one. Misrepresentation or misconduct by an opposing party. Number 4, the judgment is void. Number 5, the judgment has been satisfied, released, or discharged. It is based on an earlier judgment, has been reversed or vacated, or applying it prospectively is no longer equitable. Or 6, any other reason that justifies relief. I mean, that basically just leaves the door wide open. So this rule governs the process if you're going to attack that judgment directly. So before I get into what that means, I want to open this up to you guys. What do you guys think that means when you're saying attacking the judgment directly?
I was going to ask you, what does that mean? What example is that?
Okay, good. That's a great question. Let me see. Erica, do you know what this means?
I'm just very interested in this because I have a friend who is going through a foreclosure case, and this is applying, I believe, for her situation based on fraud. They didn't even give her a chance to, like, in the due process of things. So
yeah. So there's, I mean, and Justice knows we're dealing with this very same issue with her. Fraud, right? So you have the party that's moving against you has failed to prove that they have standing to foreclose.
Right. Well, they didn't. We started asking them for documents that proved they had ownership because my mortgage keeps changing hands. So I went out and reached out and I said, "Can you guys show me validation of my original documents? Who owns the note here?" And nobody would. So for over a year, we asked repetitively through. So then we decided to sue them because they turned around and said, "Well, we're going to foreclose on you." And we're like, "On what grounds?"
Well, and here's the problem, right? So Justice brings up a great point because in her situation, she has been exercising administrative procedures, sending letter after letter saying, "Show me the validations I'm looking for. I need to know that somebody will sign a document under the penalty of perjury that A, they have the original promissory note, and B, they have the mortgage deed. Those 2 documents are required for anyone to have standing to foreclose.
Or to collect money.
And to collect money.
I'm just saying, show me that you have the right to collect money from me.
Exactly. Well, so here's what happens, right? These big bad companies, they're just like, well, the problem we have in this state here in Utah has a non-judicial foreclosure process. And all that is it means that the party that wants to foreclose, they can simply file a notice with the county recorder that, hey, we intend to foreclose on this property. Now, generally speaking, that's not a big deal. However, if they have failed or either not failed or unwilling to prove that they have standing to foreclose, then how are you to put a stop to that? Because this is all administrative.
Right.
Everything we're talking about there is administrative. So how do you defend yourself? Well, you have no choice, but you have to sue.
Right.
And see, this is the problem that I have with non-judicial foreclosures, is it doesn't grant us the right to discovery. If you get to discovery, like you do in a lawsuit, it's simple. Hey, go ahead and provide a verified copy, one that we can inspect, one that the judge can inspect. And if you do indeed have verified copy and you are the owner of that, then hey, you have every right to foreclose.
Yeah, none of that happened in my friend's case, and the judge ruled to move the foreclosure, and there's a sheriff's sale scheduled and everything. So,
okay, so here's what your friend's going to want to do. So there's 2 ways, right? So the initial question was, when you're attacking it directly, what does that mean? Well, this rule states that you can file a motion to have the judgment vacated. It's called motion to vacate a void judgment. Because right here it says the judgment is void, right? You guys remember what we talked about? What is required for the court to have before they can issue any binding judgment?
Jurisdiction?
Jurisdiction, which type?
Subject matter.
Okay.
In personam.
And in personam, correct. Yep. Now, in property cases, in foreclosure cases, they also have to satisfy a third prong we didn't talk about, and that's called in rem jurisdiction, which means they have to prove they have an interest in that property. Okay. So in your friend's case, the company that was trying to foreclose, they must prove that they have clearly established the court has subject matter jurisdiction, meaning they're moving under a law or a common law or a statute that grants them that process, in addition to someone with firsthand knowledge and who has standing to foreclose has verified that claim with either an affidavit or a deposition, or they have taken some type of testimony under oath. That's required, number 1. Number 2, they must have properly served the other party. And number 3, they must prove that they have an interest in the property, meaning they have to bring the promissory note and the mortgage deed. Those 2 are required. They cannot be separated. They must be together. If they don't have either one of those things, they do not have jurisdiction. They have not granted the court jurisdiction, and that judgment is a void judgment. Okay.
They never do have those things because they separate them right at closing.
They never do. They never do. And then like in Justice's case, it changes about 500 different hands. And it goes from one place to another, and like it makes your head spin. Like you're trying to figure this thing out. You're like, I'm getting a headache just trying to determine where all of this nonsense has gone.
Right. And in all the documentation of all the people that said, it turns out we finally got a letter from the lawyer stating who the owner of it is some series of numbers. Not even a company.
Yeah.
And we're like, well, who's this now?
Or I don't know.
Yes, and it all started with asking for it because of I felt we were being extorted because the company, I'll say it, I'm not shy, Mr. Cooper, when my husband got furloughed during COVID, a complete government shutdown globally, we all know what happened, due to no fault of our own, many people were put out of work and lost their businesses, right? They told us the only option they had was we would get a forbearance, which typically means, but not always, you extend the life of the loan. So if you don't pay for 6 months, the loan is 6 months longer. Well, what they said was, well, you don't have to pay for 6 months to a year, however long it was. But when that is over, you then have to pay the full sum of $30,000 or whatever it is. And you're like, so an $1,800 payment right now would be stressful. We're asking for relief, but in 6 months, we're just going to magically get $30,000. So the way I look at that is that's extortion because they offered no other option. We were under duress and our back was against the wall. What are you supposed to do without an income?
Not only that, I mean, those terms constitute in contract law, those terms constitute an impossibility, number one. Right. And it's unconscionable to number two. I mean, if a party is seeking relief right now because they're under financial stress, what makes you think they're going to have $30-something thousand 6 months from now?
Right.
If they don't have it today, they're more than likely not going to have it 6 months from now.
Right.
And they should have known that. They knew exactly what they were doing. They were doing that because, like, hey, we have to do this so that we can go back to our insurance people and say, hey, we haven't collected a payment for 6 months. We need to get that insurance payment now.
And here's the proof they knew what they were doing. Because when I wrote to, I think his name is Jay Bray, the CEO or CFO or whatever, the person in charge of the company, and asked him for validation of my original article of indebtedness, I heard nothing. And then all of a sudden, this company called ShellPoint starts asking me for $30,000. And we're like, wow.
Mr. Cooper is the doing business as it's Nation Star Mortgage Services.
And they jumped out of the line of fire ASAP.
Yeah, well, they absolutely certainly tried. So, but going back to what we're talking about here. So if you're going to, Erica, let's talk about your friend. Okay.
Yes.
So she obviously is in a situation, it's a she, right? Okay. Sorry. I just presumed. So she has a couple of options. The first option is she can file a motion to vacate the judgment for a void judgment. And she can say, nowhere on the record has it been proven by the moving party, the mortgage company, that they A, have standing to foreclose, B, that anyone with personal knowledge knows anything about this because there's no sworn testimony from somebody from the company saying that, yes, we are an aggrieved party. We have Article 3 standing. We have suffered an injury in fact, right? So she can file a motion into that case. But the issue I run into with that is you're filing a motion and it's going right back to that same judge who just said that they had jurisdiction. What's the likelihood that he's going to, oh, you know what, you're right, I made a mistake. Okay, this judgment is vacated. What's the likelihood that's going to happen?
Not likely.
It's not.
She's part of the crime in the first place. So
yeah, I mean, and a lot of these judges in these courts is your friend there in Indiana with you as well, or in a different state?
Yeah,
Indiana. So Indiana is a judicial foreclosure state. It sounds like, right? Because she's in a court.
Right.
Okay, so at least you have that. We don't have that luxury here in Utah. We actually have to instigate our own lawsuit, which is fine. You know, it's not a big deal now. But they were counting on this that the majority of the homeowners that were in a situation like this wouldn't know what to do, and they would just let them foreclose, and they think, well, I just lost my property. Okay, it's very very clear. Read your state constitution. If you don't know your rights, you have no rights, and you have a right to due process of law. You cannot be deprived of anything, not your life, not your liberty, and certainly not any of your property, without proper due process of law. They can't just come in and say, oh, well, we did everything here, and this follows due. No, it does not. I have a right to face my accuser. I have to face no one. I have a right to cross-examine someone who's making a claim against me. I had no opportunity to do any of that. So this is how we assert that.
So James, she should file a judicial complaint, should she not?
That's the first thing I would do. Number one, file a judicial complaint against that moron judge and say, hey, you got a judge in here who doesn't even know the law. So that's the first thing I would do.
For those who are new to this, can you just explain what that judicial complaint will signal to the judge?
It's not really going to. I mean, all it's going to do is this is incorporating the politics side of it that Randy talks about, right?
But they do it, so we have some merit in doing it, right?
It does, because again, judicial complaints don't get filed very often. And so if you go file a judicial conduct complaint against this judge and say, hey, this judge not only A, is biased, but B, doesn't know the freaking law from their head. So they clearly don't understand what due process of law is. They clearly don't understand what's required in order for someone to have standing to foreclose. So this judge needs to, at the minimum, needs to go back to law school, but they probably shouldn't be a judge. So that's kind of...
gloves are off with this one.
Yeah. Yeah. That's what I would do there. The gloves are off. So in your friend's case, that's the first thing I would do is I would file a judicial conduct complaint. The second thing I would do now, if you want to file a motion to vacate, to put it in the record to show, you can do that. If you decide you want to take it to the appellate court, you can do that. I, for one, would rather attack it collaterally because then you can sue the people who brought this claim against you for all this emotional distress and time you had to spend here. And you can sue them collaterally. That's the other option. So let's talk about that. What does that mean? Suing them collaterally. Let me share my screen again. While I'm opening that up here, what do you guys think a collateral attack is?
After money.
Okay.
I mean, collateral is some sort of belonging in the word collateral, so it's got to be.
Yeah.
I don't know.
So in this term, a collateral attack means you're filing your own lawsuit in another court attacking the judgment of that court.
So what does the word collateral mean?
It means it's a side two. Side by side, yeah. It's a side two as opposed to being a part of the original action.
Okay.
Right? So going back to Erica's friend, so like I said, she could file a motion, which would be part of that original action that was instigated by the mortgage company. But I would rather file my own suit naming those mortgage people as defendants. You can name the judge as a defendant too, if you want to. It's going to be difficult, but it's you know, the minute that judge issued any kind of ruling or did anything without proper jurisdiction, the judge has no judicial immunity.
Right.
So judicial immunity does not apply when a judge is just acting willy-nilly just because he puts on a black robe and calls himself a judge. Right. So where I go to know, okay, when is it appropriate to attack this judgment collaterally? Well, where else but American jurisprudence? So where I'm at right here is I'm under the topic of judgments, relief from judgments, and its collateral attack. And this is the general capabilities of attacking a judgment collaterally. So let's read this. It says, a final judgment by a court of competent jurisdiction is generally not subject to collateral attack unless it was procured by fraud, regardless of whether it was rightly or wrongly decided. Okay. Again, keywords there is competent jurisdiction. In other words, where the court has jurisdiction of the parties and the subject matter, its judgment is generally not subject to collateral attack. So if the moving party did their job and they A, brought a verified complaint, and B, somebody who could swear to the truthfulness of it, the court has the subject matter jurisdiction it needs. However, a collateral attack may be allowed if the judgment is void, such as where a judgment was rendered by a court without jurisdiction.
Booyah.
There it is.
Would this also be known as a countersuit?
Yes. Okay. Well, sort of. Okay. A countersuit is one where, like, let's say, for example, I was to sue you, Justice, and then you're like, well, you're way off into the weeds. I'm going to go ahead and countersue you. That's a countersuit, right? So I've sued you, you're suing me back, and it's all part of one action. This is a whole separate action. Okay. It says here, if a judgment is voidable, a collateral attack thereon is generally unavailable. Thus, even if the judgment was so irregular or defective that it would be set aside or annulled on a proper direct application for that purpose, as a general rule, it is not subject to collateral impeachment as long as it stands unreversed. That's weird. Is that your microphone again?
It's my...
Oh, dear. Okay. Does that make sense, what I'm just saying there? What we just read?
Yeah.
So the key to all of this, you guys, is the fact right here where it says, if the judgment is void, such as where a judgment was rendered by a court without jurisdiction. Now, Erica, let me go back to you. Can you waive in personam jurisdiction? So if you're not properly served and you answer a complaint, can you go back and say, well, I was never properly served. You got to properly serve me.
Yes.
You sure?
No.
I love that. Typically, no.
You'd think so. But...
yes. In personam jurisdiction, that can be waived. You can waive that. You can say, you know what, forget about it. I'll go ahead and just move forward with this. All right. Now, on the flip side of things, Erica, can subject matter jurisdiction be waived?
No.
It can never be waived. Never be waived. Right? So we went over this last week and the week before. The court must have subject matter, must have jurisdiction over the subject matter, meaning it's a statute or a law that they can hear, happen within their territory and their jurisdiction, as far as that goes, the territorial jurisdiction. It also must be brought by someone who has standing, someone who has suffered an injury in fact. Okay? So let me ask you this. If you are driving down the freeway and you get pulled over by a state trooper and he says, my goodness, what's your hurry there, speed demon? And your answer to him is, I don't answer questions. Good girl. Then he's going to be, all right, well, here's your ticket. He hands you a ticket. And on the ticket, it says you need to show up in court at this time. Does that court have subject matter jurisdiction to hear that case?
No.
Why?
Because there was no damage to anyone who could bring forth a complaint against me.
There you go. But the plaintiff is the state of Indiana. The state of Indiana versus Erica. And the pompous attorney on the other side is going to say, well, the statute says we have attorney, the legislature says we have jurisdiction to prosecute these things. And this is the proper venue for this. This is the proper court for this.
What damage did I cause to any single person? How can I stand before my accuser?
Still no harm done.
Okay, yeah. You're moving in the right direction. The question I would ask you is like, okay, who has standing to bring this claim against me?
Right.
Who can prove an injury in fact?
So something closer would be if the actual police officer had her in court between he and her.
But he would have to prove that she harmed him directly.
Right.
Not in his capacity as a police officer, one who is employed by the executive branch. They do not have Article 3 standing.
Right. I'm just saying that would be a closer scenario for the situation, not the corporation, which could be 100 people.
Yes. Yeah. You just, what we're trying to convey here is it is impossible for you to harm the entire state or the corporation of the state. They have suffered no injury in fact, and they can prove no injury in fact. Therefore, they do not have Article 3 standing to bring a claim against you, one of the people. Now, they're going to say, well, the legislature says we can do this, and this is what we're going to do. Okay, that's great. You go ahead and do what you're going to do, but I'm telling you right now, this court has no subject matter jurisdiction to hear this. Oh, and by the way, Mr. Judge, if you choose to move forward with this case, knowing you don't have subject matter jurisdiction, I will personally hold you responsible. There's nothing wrong with that. These people are our public servants. They work for us. You need to tell them that. You work for me, not the other way around.
And when they bring up the fines associated with your crime, then you call out the bills of attainder,
Yeah.
right? That's what we talked about.
Hold up. I'm waving my little flag here. This is my unconstitutional flag. Hey, Judge, you know what? Article 1, Section 24, which I believe is here in Utah, says that there shall be no bills of attainder or ex post facto laws. So how is it that the legislature can prescribe punishment? Doesn't that violate the separation of powers? Well, yeah, but the statute is what it is, and they're prescribing these outlines for us, so we have a guideline to go on. Oh, okay. So you mean you don't actually just you don't actually take the testimony of someone who was actually injured and determine the amount of damages based off of that? Is that what you're telling me, Mr. Judge? Ian, what we're talking about are the administrative courts. This is exactly what it is. Okay? I'm here to tell you, it is very rare, unfortunately, that a constitutional court is taking place anywhere. The only time that those courts are invoked is when people like us properly serve someone and properly sue someone. But if you're receiving a summons in the mail or something like that, or you get a ticket from one of these glorified security officers with a badge and gun, that's all administrative, 100%.
And there was something that we saw recently too, Justice, about the seals for the courts to prove that you're an actual court that can even bring this stuff.
Yeah, we were talking about that. I don't know. Were you with us that day, Eric? I don't know. Maybe I don't think you were.
It was the last broadcast. She was sick.
The last broadcast. Oh yeah, you were sick. Not the last one. The one before.
Oh yeah,
I said you need to check the laws there in Indiana because James can't find. I haven't looked, but James said he couldn't find anything to where that is applicable to such a fine-tuned degree here in Utah.
Yeah, yeah. So
that was California laws and rules, so you would have to look there.
Yeah, that video was produced by. I mean, and kudos to her. She did a lot of work.
Right.
But she found the laws and statutes of California that prescribe exactly what the seal is supposed to look like, what it's supposed to say, how big it's supposed to be embossed, all of these things. Right. And I couldn't find anything like that here in Utah. The only law I did find was it says that the only time that a seal is required is when it's signed by an officer of the court. Well, summonses are supposed to be signed by an officer of the court.
Right.
So where's the seal? So just because it says summons on there, if there's no seal of the court, it is not a proper summons. Okay. My
peon brain just doesn't understand how these administrative courts are even allowed to be in existence as they are anyway.
Well, so there's a purpose for them, right? When the founders, when they started, putting pen to paper and saying, okay, how do we organize this new nation? How do we create this government, which is by and for the people that are supposed to work for us and protect and guard our liberties? They said, well, we're going to have situations that involve where we're going to need to be able to prosecute people administratively, where they didn't commit, say, a common law crime, but maybe they violated policy, maybe they violated procedure, which is what statutes are. It's just policy and procedure for all of our government agencies. So that's what administrative courts are for. However,
agencies who violate their statutes.
But that's what I'm saying is they are misapplying. It's no different than McDonald's trying to charge you for violating one of their policies and procedures. You're just like, get the crap out of here. I don't work for you. Right. I have no contract with you. I have no obligation to you. So that's the same approach we have to take in these administrative courts if we're being dragged into there for one of these quote unquote violations of policy and procedure. We need to just take a step back and say, okay, hold the horses here, Judge. For number one, Randy talks about it this way. Randy Kelton and Brett Fountain, they say, I'm here at arm's length, right? I'm here at arm's length to the court. That's the same thing as I'm here by special appearance. I am not here by general appearance. I'm making that very clear. There is nothing on the record to show that this court has A, in personam jurisdiction, and B, subject matter jurisdiction over me and over this alleged controversy. I'm letting you know now, I have no contract or obligation with the state or with the city or with the county or whoever it is that's moving against you. Whatever name is listed there, if it's the local city, township, village, or wherever you are, they call them. I mean, they're everything in every state is different, right? So if it's the village of this, if it's the city of this, if it's the town of this, if it's the township of this, I'm going to require proof that I have a contract with them because that contract would prove that you can move administratively under me.
Right, like when they tell me I can't have chickens because of the city ordinance.
Exactly.
Show me the contract.
Hey, Mr. Ordinance Officer, take that ordinance and shove it up where the sun don't shine. That's what I would say to him.
That's what I did say.
Well, I'm going to issue you a fine. Be my guest, but don't you ever step foot on my property again without a proper warrant of the law. Otherwise, I will use the force that I have at my fingertips. Right?
Right.
So you're right. Who's to tell you can't have chickens? Are those chickens harming you, or are they infringing on anyone else's rights?
Right, and they're not prehogs from the Minority Report that can anticipate that it's going to be a problem someday, maybe for someone.
Exactly. We had this discussion, and I want to get back to Ian's question in a minute, but we had this discussion the other day when I was driving with my family. I was driving down my road, and it's not a country road, but it's not a very busy. I mean, there's very rarely any traffic on this road. But these people that put up those ridiculous speed limits that have it tells you what your speed is, right?
Yeah.
Have you seen those digital radar guns, and so the speed limit's 35, and I'm going like 42. And my kid's like, Dad, you're speeding. That's against the law. And I'm just looking around going, okay, and who is hurt by my actions?
Mm-hmm.
Right.
Whose rights did I infringe? If there was another car on the road, I would slow down.
Right.
Right? That's because we're competent adults and we can grow up.
Well, you know what?
Use the brain that God gave us and know that, hey, it's common sense that I shouldn't be driving this fast if there's other people or cars around.
Some adults are not competent. We have one of those in our neighborhood. Now, imagine this. A neighborhood.
Mm-hmm.
Children and animals,
Mm-hmm.
wildlife. 3 moose have been killed in my neighborhood because people speed down the road. 50 miles, we have a straight shot. And it's very sad, a mother and a baby and another baby because of people speeding. So some adults are not competent and
they're not
always in a hurry. And they had speed bumps. They took them out. We have one of those in our neighborhood for that very reason. Literally the neighborhood paid to put a moose sign. If you go above 25, all the lights start flashing to remind people. And it's not just that. I mean, you can get killed yourself too.
Yeah, I mean, there's a reason why those speed limits are there. Use reasonable prudence, people.
They're suggestions.
Yeah, I go back to the whole Pirates of the Caribbean thing, right? Where that lady says parlay, and she's like, "What? Mm-hmm. Parlay? I invoke parlay." And he's like, "By the rule of the Pirates Code." He's like, "Whoa, whoa, whoa! Those are more like guidelines." Mm-hmm. That's kind of what I think of them as. But the point I'm trying to make here, guys, is we have these laws on the books for a reason. But it's just like you said. It's like, well, we don't have precogs. They're going to tell us when the next crime will happen, so that we can go stop it before it happens.
Right.
It's not the unfortunate thing about this world we live in with the people that are on this planet is we are always going to have somebody who's going to do something stupid and hurt someone else. There's just no way around that. That's why we have this resolution process. So Ian had a great question. So you're stuck in an administrative court. How do you flip this into a judicial process? That's a great question, Ian.
It is a great question.
So from my experience, there's really nothing you're going to be able to do in that administrative court to turn it into a judicial one. They're just going to ignore everything you do. Well, we don't do stuff like that here. Don't come in here talking to me about your constitutional rights. You don't have those here. I've actually had judges say that. I've heard judges say that. And
can you invoke a common law court?
No, there's just really nothing you can do. So here's my suggestion, guys. If whatever you're dealing with, if it does not deal with jail time, okay, if jail is not on the table as where they want to send you to jail because of this, I would file paperwork into that process. I would object to everything they're doing, put it on the record. The court has no subject matter jurisdiction. The court has no in personam jurisdiction. There's no one with no one who has suffered an injury, in fact, bringing a legitimate claim against me. I would file that paperwork as a motion to dismiss into that court. Let that judge go ahead and ignore it. Great. You sit right there, Mr. Judge. I'm going to go sue you over in federal court. That's my collateral attack there. I'm going to go get an injunction from the federal court saying this court is attempting to prosecute me administratively without affording me my due process rights, without proving all of these things. I am likely to succeed on the merits of this case, and no one is harmed if this court grants this injunction. I'm going to file a lawsuit alleging deprivations of my rights under the color of law, Title 42, 1983, and I'm going to file a motion for a preliminary injunction along with that. Get that federal judge to sign that paper that says, hey, moron, stop doing what you're doing. That'll put a stop to it.
So, James, is that a collateral attack?
That's a type of a collateral attack, yes. It's not the collateral attack in what we're talking about here. Now, let me go back to the next thing that I was saying. What if jail time is on the table? What if they're trying to put you in jail? Unfortunately, they're your only option, and I haven't found one away. I mean, you can try to go the federal route. Sometimes they move pretty quickly. Sometimes the only thing you can do is accept some type of a plea deal. Now, let me remind you, just because you accept a plea deal does not mean the court had subject matter jurisdiction, because you can never waive that. So just because you accept a plea deal, and let's say the prosecutor says, all right, well, I will take jail off the table, but you've got to be 6 months this, or you got to be confined to your home or whatever. Just anything that can give you your liberty back until you have the time to fight it properly. So even if you accept a plea deal, you can still attack that judgment because the court never had subject matter jurisdiction. Never had it. So does that answer your question, Ian? I hope so. I hope that answered what – I don't know. You guys tell me. Does that answer the question that he was trying to get?
Yes, it seems like it. It seems to me, how do you get it out of the administrative courts into the judicial court?
Yeah.
By counteraction.
Yeah. Well, there are a couple of other things we can do. So let's talk about, all right, how do we initiate this collateral attack? Let's say it's one of these minor misdemeanors, or it's a traffic offense, or it's something just minimal. And it's like, I'm tired of this. I'm tired of these people running me through the ring, extorting my money, my hard-earned money from me. So what can you do? Well, you can file what's called a petition to vacate a void judgment. And I'm going to pull one up here for you guys.
Petition to vacate a void judgment.
Yep. Okay. So many of you guys know I am a big fan of Richard Cornforth. Mm-hmm. He's the one who said he discovered this back in 1993, I think he said, 93 or 94. So it's been a long time ago. He talks about these people here, this Melvin, this Bessie, these other people. Just a quick backstory. These folks here were all homeowners in a homeowners association in Arizona. And I don't know exactly the whole details, but somehow there was commingling of funds. So these people chose not to pay their homeowner association dues. Because of that, there was somebody was extorting, but what's that word I'm looking for? Embezzling. There we go. They were embezzling money. And so the Happy Trails Acquisition Limited Partnership decided to sue them. So these people here, this Melvin and the Bessie and these other folks, they decided to play the Patriot mythology games. You guys know how well that works out, right? It's very similar to the Hunger Games. May the odds be ever in your favor.
Yeah, I'm still searching for someone that's had success with that.
Well, I'm here to tell you these folks didn't have success. They filed sometime. I mean, Richard, in the video that I watched, he had a copy of their pleading, and it was the size of a 3-ring binder that was 3 or 4 inches tall. That's how thick the pleadings was. So they went in there and they just said, we stand on our pleadings. They didn't say anything. We stand on our pleadings. And apparently the judge in this case tried to do everything he could to help them. but they just wouldn't listen. So they ultimately ended up losing, and they got a $6.8 million judgment against them. $6.8 million.
That's heavy.
Okay. So what's interesting is the judge in his order said that they were all severally and equally liable for that judgment. So what that means is everyone had to pay an equal amount that would equal that total, the $6.8 million.
Oh, and how many of them are there? 6?
There was 1, 2, 3, 4, 5, 6, 7, 8.
Oy.
Okay, still, for 8 people, that's near impossible. So they reached out to Richard, and he looked into this, and he's like, all right, let me take a look and see what I can find. And he found in Arizona that they passed a statute, right? Statutes are policies and procedures for members of the public organization, people who work for the public. And the statute prohibits that a court can issue a judgment that is equally and severally liable. They can only be liable for their portion. They cannot be equally and severally liable. That makes sense?
Yeah.
So he wrote up this petition to vacate a void judgment. And so for those of you who might be listening, it's only 4 pages long. 4 pages to vacate a $6.8 million judgment. And this is what it says. It says, these individuals, I'll save some time and not read their names, hereinafter identified as plaintiffs, petition this court under the authority of Arizona Rules of Civil Procedure and the common law doctrines established in American Credit Bureau versus Pima County for vacation of a void judgment in this case number, a copy of which is attached. The face of the record shows that the plaintiffs in the above styled cause were not in receipt of notice of complainant's motion for summary judgment in the case, had no means to know of motion for summary judgment or the hearing conducted to determine liability. The plaintiffs were deprived of procedural due process rights. The clear face of the record shows that the court did not have jurisdiction over the parties, a procedural due process requisite for determining liability. Jurisdictions of the parties and subject matter is essential to a valid judgment, and court must have jurisdiction to enter the particular judgment. A judgment is void on its face and is subject to collateral attack unless court has jurisdiction of the subject matter of the persons involved in the litigation and to render the particular judgment given. He says this trial court had no jurisdiction over person of defendant who was never served with a summons and complaint, who never appeared in the declaratory judgment action, and who only filed notice requesting copies of all minutes, entries, and documents long after trial. Therefore, judgment as to such defendant was void. So then there's some cases here that he's using to back up his position, which is what we should do. He says the complainant's action to determine liability was not procedurally or substantively a provisional remedy. Before any provisional remedy shall issue, the party seeking such remedy shall establish with particularity by affidavit to the court's satisfaction sufficient facts supporting the party's claim and establish that one of the requirements of subsection A of statute authorizing provisional remedies has been met and that such party will file such other pleadings or affidavits as required by law as a prerequisite to the issuance of any provisional remedy sought. Okay. He talks about how the court wanted subject matter jurisdiction to find all of these folks jointly and severally liable. It says the court made no inquiry into individual culpability of each respondent. The court failed to apportion degrees of fault. The court in this case made no finding that any party was responsible for the fault of any other party. And this is where he talks about joint and several liability has been abolished in Arizona, excepting where degrees of fault have been apportioned. Okay, I won't go through everything else here, but basically that's how you attack a void judgment collaterally. You file a petition, which is nothing more than it's another case in another court, and you attach the record from that other court. So going back to your question, Ian, where you're saying what do we do in these administrative courts? Well, you're still going to get a copy of that record, and you're going to say I need a certified copy of the court record. They're going to give you everything they have. They're going to show all of the paperwork you filed into the court. You're going to attach that to your new lawsuit, and you're going to go sue them in another court. You can sue them in federal district court. You can sue them in another state court if you want. It doesn't matter where you want to go. I just prefer the Fed. That's just me, but you can go wherever you want. And that's the process for how you do that.
So now, James, is this like another way of filing a motion to dismiss?
Sort of, right? Because
you're just trying to get it.
You're trying to get the judgment vacated because, again, the court can, going back to what we talked about before, right? Courts inherently do not have jurisdiction to hear matters. They cannot on their own just go ahead and, we're just going to go ahead and prosecute this person.
Right.
They can't do that on their own.
So when it's vacated, is the case over with? And when it's dismissed, is the case over with? Or is there additional steps on each?
No.
Okay.
No.
So they're both, the result is the same.
Yeah. So if you file a motion to dismiss in the administrative court and you actually have a judge that has a brain in his head is like, I don't want to mess with this guy.
Right.
And he dismisses the case.
Right.
The case is over.
You see that this case is dismissed and it's done.
Yeah.
So I was curious if that meant you had to, with avoiding, if you had to continue on with another type of action afterwards.
No, it doesn't happen. It doesn't happen very often, but it does. It does happen. So, but if you file a petition in another court to vacate that court's judgment, you're entitled to damages. Because guess what you have? What do you have, Erica?
Subject matter jurisdiction?
Yep, you have standing.
You have standing, yeah.
You can prove actual damages. This court subjected me to an unlawful fine. Let's say it's $1,000. They fined me $1,000. Does this court subjected me, so I have actual damages of $1,000. Oh, and I'm suing them for punitive damages to make sure they don't do this again. That's what punitive is. We talked about that last week when we were talking about, what constitutes a bill of attainder. It's legislation that prescribes a punishment. And if that's typically a punitive damage, like we said before, if the statute says, well, whoever's convicted of this must pay $1 million fine, it's like, well, who gets that money? It's not you. It's not whoever was damaged. It's not whoever was hurt. That's a punitive damage. So that's how that works. That's what I would do, right? I'd also bring up the same thing in, if I'm collaterally attacking this in federal court, I would bring in and say, hey, this process violated all sorts of rights. Not only that, it violated the constitutional provision that no bill of attainder should be passed. Because as this moving party was applying this law to me, they were misapplying it to me. There's no contract. There's no obligation that was entered onto the record by validation by anyone who has personal knowledge of it that would prove that this statute applies to me. So, yes, Ian, you would just pay the fine at the admin level. I mean, if it's not a serious fine, a lot of these stupid administrative courts will do a payment plan for you. Sure, whatever. Do whatever you got to do to get out of there and then go and attack it properly. Because the only way that madness stops is when more and more of us start filing these collateral attacks.
Right.
Start suing these people.
And more and more people are aware.
Yep.
So when you were showing, I know there's numerous websites. I think it was Brett talking about some today where people can go to learn these definitions. And because these things are very confusing, right? How would somebody know unless they're watching something like this? Or where do they go to learn the definition? So you had just had a website up, and I know there's another one called Pacer that he was talking about. Explain some of these websites for the folks so that they know where to go get some resources. So besides some we're going to share at the end.
So the website I had up was American Jurisprudence. And that is, unfortunately, you can't just get it for free. I wish it was, because it's super valuable information. So it's actually available through Westlaw Classic through Thomson Reuters. There is a subscription cost to it. It's not terrible, but it's not cheap either. So again, they're mainly, this is mainly made for the attorney profession.
So this is westlaw.com?
Yeah, it's westlaw.com. Yeah, you can search it out. Search for American Jurisprudence. You'll find it. You'll find a way to subscribe to it if you want to. You don't have to. Again, if you go into our group in Telegram and say, hey, can you find what American Jurisprudence says about this? Then
another really good resource too is, like, here in Indianapolis, we have a law library, and the people who work there know everything, and and they have subscriptions to everything. So if you just go in there and you tell them what you're looking for, they can help you find it.
Yep, this is a great, good question, Jolanta. So I'll let Justice tell you what she did, but basically she just wrote to him and said, "I need proof. I need proof of who you are."
So in other words, did they extort you after COVID as well and asked you to pay everything up front? So whatever your situation is, if you're wanting proof. James told me to ask them for the original articles of indebtedness. So since that's who I was dealing with, my original mortgage started out with Citibank. And I can't even tell you the long debacle up to this point. But they seem to have sold or transferred the loan numerous times up to this point. And when I wrote directly to, I believe it's James Bray. You can look up the CFO of any company or the CEO of any company online. You can look for their headquarters, their address, their corporate address, and so forth. And I sent a return receipt registered letter asking him for the original article of indebtedness. It's the only thing I asked for. And I expanded that list as we went on with other people. But from that point on, I heard nothing from anybody from Mr. Cooper. And the next thing was I started getting statements from a company called ShellPoint. And they were trying to then collect, I think it was $30,000 at the time.
Yep, they still are.
And now it's up to 50 or something. And nothing's happening. They just keep robotic, keep sending statements and so forth. And I keep asking ShellPoint, who are you? Where did you come from? And why do you think you're entitled to me paying you any money? Yeah. So I have no idea why and when, but clearly Mr. Cooper must have, is my assumption, you know what they say about assuming, put them to try to collect the debt. It's a collection company when you look them up. And when I started asking for them, same thing. Not only did I ask them for the original articles of indebtedness, which they would need to provide a certified copy of it. Or I even said, you send it to me, I'll send it back, right? But they didn't offer anything except for a photocopy. And I said, in this day and age of digital fraud, number one, how do I know something's been tampered with? There's fraud running everywhere. And my whole purpose for this letter is to see if mortgage fraud has been committed. I was upfront with them. Yeah. Because I believe it has been committed. And I believe long before these people even got involved.
Yeah. It goes back pretty far back.
Right.
But real quick too, Justice, not to cut you off. If you request validation from these people, right? So there's a federal law. It's the Fair Debt Collectors Practices Act. Most of these, unfortunately, mortgage servicers do not fall into that category, which is ridiculous to me. But the Congress has said when you request validation, that requires somebody signing something under penalty of perjury that what they have is real. So that would suffice too. So this document that they send back to Justice, where it was just a photocopy, if they had done their job and went out and said, I swear under penalty of perjury that we have this document and we are the owners of this and it's notarized, that changes everything. But they didn't even bother doing any of that.
Right. So the document we're looking for is the original contract with our wet ink signature.
It's the promise.
Not a photocopy. Yeah. So that's what we were asking for. And no one has been able to provide it. And they're saying that this is valid. So my thought is, if a photocopy of my original contract is valid, then so is a photocopy of my driver's license. And I can hand that over to the cop.
Yeah.
And I can hand that to the judge when I go in to prove who I am. It's not valid. It's certainly not valid at all in any way, shape, or form, and wouldn't hold up in a court if I were to go into court and show them a photocopy of my driver's license or a photocopy of my marriage license or birth certificate at the motor vehicle to attain my license. None of that is valid. So it's escalated because they sent a copy, and I said, I also want to see where, I don't know if you guys know this, but it's illegal to lend credit, right? So they have had to fund the bank account. And I said, show me the funding of the bank account also. Right.
Yeah.
And so anyway, to make a long story short, they're not providing any of these documents whatsoever. And just so that you know, as James said earlier, I don't know when you came into the broadcast, but Nation Star is the originating company, and they changed their name. I still believe it's part of the same corporation, isn't it, James?
Yeah. So Mr. Cooper is just doing business as.
Right. Okay.
So they are Nation Star Mortgage Servicers doing business as Mr. Cooper.
And there are class action lawsuits, a lot of them with Nation Star, which is probably why they changed their name. But so that's what you're asking for. Is you're asking for a certified copy of the original article. You want to see that someone has, because the contract is null and void if someone doesn't have it.
Yep.
If they don't have your original wet ink signature, mortgage, and note together, the mortgage is null and void.
Not only that, Justice, but here's the other thing too. The contract must be one that can be assignable. You have to agree to that. They have to agree to that. How many of you, Erica, when you bought your house, did you sit down and read through all 365 pages of closing documents?
No, they just hand these papers to you and they give you the gist of it. They say, this is just saying that you blah, blah,
yes.
sign this.
This is just saying this. So do you really have a meeting of the minds?
Absolutely not. They don't tell you that you're funding your own loan. Like That's essentially what's happening. They don't tell you that they open up an account for you on your behalf to obtain the funds, which they then use and make tons of money off of it.
Your promise to pay.
They dig into the coffers from the Federal Reserve, right?
And they separate, and you can subpoena that after you file your case in the discovery. It's called the OC-10. With the Federal Reserve. It's this whole packet of information that they file for you to obtain the funds that way. And then they put it into their accounts as a deposit and then pretend like they're loaning it to you after you just created the money and then tell you to pay it back with interest.
Round and round and round we go. Where are we stopping?
And the second you do the closing, they separate your mortgage from your promissory note because then they use that promissory note to make money off of it. You can get a securitization audit to see just how far around the world things go.
That's illegal. That's called bifurcation. And the note has to stay with the mortgage. So when they separate one electronically to have the process done quicker, it's bifurcated, and that also makes it null and void. There's a really great video. We have it in Affidavits 101. I'll dig it up and post it. So if you're not on Telegram, I'll put it also in the notes of the YouTube channel and watch it. It's 20 minutes, and this gentleman explains it step by step of the mortgage fraud process, which is pretty much almost everybody in America. The last modification did on my loan did say it's not a MERS loan, which MERS is the electronic version. So I think that because they've been caught now, they might have stopped doing that. I have no idea, but this guy explains it beautifully. So to give you an idea of what's going on with the fraud of this, I'll put that in there so you guys can listen to it. I highly recommend it.
Yeah. You guys can see where we're going with this. I mean, it's just a mess. It's an absolute mess. I mean, Ian, who knows?
That's a great question.
Who knows who holds the original note, right?
This is what we're searching for.
The idea, this is the simplicity of this, how it's supposed to work, right? I go to Justice and say, Justice, I need a loan to buy a house. Justice says, okay, I've got the money. Promise you'll pay me back over X amount of years and you'll pay me X amount percentage in interest. So I say, okay, we agree. I sign the paper. She signs the paper. She hands me the money and away we go. I sign over to her a promissory note, which is my promise to pay the money back. I sign over to her a mortgage deed, which grants her ownership and interest in the property. Should I fail to pay it back, she can foreclose. That's how simple this is. Both documents are required. They cannot be separated. And they do it all the time.
Right. And there's a great little book too. What is it called? My Home is My Castle?
My Home is My Castle.
Yeah.
And it talks about the process as well. You could get it on Amazon.
Yeah, I mean, I know. I apologize. We're kind of getting off on the weeds here, guys. Yeah. But God, we could spend another 2 or 3 episodes.
Yeah, I think we want to do one on mortgage fraud specifically. So
yeah, we absolutely need to talk about it in more detail. But for the purposes of today, I wanted to teach you and give you tools on how you can do that. Now, I am going to be working on some of these things, and for everybody that's on Telegram, every single document, every lawsuit, every motion, every petition that I write, I post there. I put it there for you guys to have it because I'm a visual learner. I need to see an example of something. It helps keep me in line and go, okay, this is how it should be written out. It gives me a timeline of events. So I post every single document that I write in any of the cases that I'm working on in my affidavits channel. You guys are welcome to go look them up and use them for your purposes. So with that, going forward for our next broadcast and more broadcasts down the road, I would like you guys, those of you who are watching or listening, to reach out to us. Reach out to us on Telegram. Reach out to us through YouTube in the comment section. Reach out to us on, where are we? We're on Twitter now, apparently.
Yeah.
Reach out to us if you have a problem that you're dealing with and you want some step-by-step help as far as this is what you should do, when you should do it. Ian, I see that you can't post on my Telegram page. Post it in as a comment on YouTube. If you want help, I want to start dedicating more time to bringing you guys on, if you're willing, to talk about your situation. We'll talk about what you can do and your next steps going forward. So even though we're not on a radio broadcast, so to speak, where people can call in, I'd like to kind of create that type of an environment. So that's what I'm thinking. What do you guys think about that?
I think that's a great idea. we can do live workshops and Q&As. I mean, we always have the Q&A, but to bring someone else on the video to talk about, that was the wrong one. And we also, don't forget, we created this at the get-go. And it's very simple. Some things need to be updated, but it's the simple steps through this process, which is accompanying your lawsuit, which is a major part of it. We do have a website, which we're going to be updating. But I think that's a great idea, James, for sure.
I know there was a gentleman who reached out on Telegram asking if I would be willing to do a one-on-one. I would love to. I can't. I don't have the time to dedicate to just do one-on-one. But what I can do is bring you on to the podcast, to the broadcast. Let's talk about your case. Maybe there's somebody else like Jolanta who is dealing with the same issue that Justice is. And so if we can talk about what you're dealing with, what's going on and what's happened, maybe we can give you some ideas. Again, this is not legal advice. Don't take anything I'm saying as legal advice. If you do, you need to have your head checked. There you go. That's my disclaimer. Okay. Maybe we can give you some strategies, some tools that you can utilize in your own situations. So, and yes, Jolanta, she brings up a great point here. She's like, bank foreclosures would be a great one. We are starting to see more and more of that again, right? It's 2008 all over again. Starting to happen again. There was a lot of changes that they made after 2008 where they made it near impossible for anyone to get a home mortgage. They're loosening those restrictions again, and now we're starting to see it again as interest rates have been creeping back up, thanks to this wonderful economy we're living in right now with people have money coming out their ears. So Erica made this awesome face. Remember, Erica, there are people listening on podcasts, so you need to express your feelings through your voice.
Oh, okay. It's made a crazy face.
She's like, that's not right. So,
and we're, I've reached out to Richard Cornforth also because he specializes in mortgage fraud, just like Steve Emerson specializes in property taxes and so forth. So keep your fingers crossed. We get him on the show to help, and we'll do a show focused on that because it seems to definitely be.
Yeah, it's a big issue. It's a big issue. I mean, we can talk about, down the road, we'll talk about credit cards, right? How many of you have been hounded by a debt collector that has, quote unquote, bought credit card debt from somebody? Credit cards are revolving contracts. It's a revolving contract and it cannot be sold.
From what I understand, even debt collection companies are illegal.
Yes, to a certain extent. If you know what you're doing, I mean, they're skirting that line, right? Getting right next to the edge. Some of them go a little bit over and they come right back. A little bit over and come right back again. If you know how to handle debt collectors, you'll never hear from them again. I got a letter in the mail from some no-name company saying that I owed them money that they bought this debt from Sprint. I had Sprint like 5 years ago. Now out of the blue, I'm getting something from. I was like, "Who the heck are you?" I got a letter back and said, "All right, go ahead and prove this. I'm going to need this, and someone's going to need to sign under the penalty of perjury. This, and this, and this." I got a letter back from him that says, "We checked with the original creditor. This is valid." I was like, "I'm using that to wipe my rear end because that's about how that's how much how much that paper is worth that you just sent that letter to me on." They did nothing that I asked for. So if they continue to harass me, well, I'll take it to the next level. I might be nice and send them a letter that says, "Well, here's your notice and intent to sue, unless you leave me the crap alone."
Right.
So
I just got something from Sprint too. They must be
It's when they work with T-Mobile, all crap.
They're all the same company anyway. They're all owned by BlackRock, so it's really such an illusion.
You just keep taking us down those tangents that I would love to go, but I can't go there today, Justice. We don't have time.
I know. Sorry. Write it down on your notepad. There's so much.
I got it right here. So, all right, everybody, we're wrapping up to just about shy of an hour and 15 minutes. I know I always say I want to keep them to an hour. We end up going a little longer. I hope this is good information. I really just want to empower you people. I say you people. I want to empower people to know what to do. I'm an action taker. When I was learning this stuff, I would hear people like, "This is great, but now what? What do I do? How do I affect these change?" And I'm hoping I'm giving you those solutions. If I'm not, please let us know in our Telegram channel, in the comments section of the YouTube video, on Twitter, on all of these platforms we're on. Let us know. Let us know what we can do to make this easier to digest and help you guys get the remedy you need. So
I think we need to bring Erica's lawsuit to the forefront and goes through some of that, because between the medical and the military and all these people that have been.
Oh, that reminds me, Erica, did you see? I was reading a complaint that would be perfect for yours.
Oh, I found a really good one too. I'll have to share it with you. I'm on the live.
I found one that somebody posted, and it's ESPN is sued by former workers. Did you see that one?
No, I haven't seen that one.
I'm going to text this one to you because this is really good. Read this one because they do a great job of creating the nexus between the state and the private actors, which is what you have to do.
Right.
So, I mean, it's 83 freaking pages long. I don't suggest that by any means, but it's really good in some areas. So take a look at it.
I'll send you one too. That it did a really great job of connecting with the state nexus and brought forth all the fraud and proof of it in addition to it. So.
Okay, cool. Good to know.
Yeah.
All right, with that, everybody, I'm going to tell you happy Friday, Friday the 13th. Oh, geez, I didn't realize that. Friday the 13th?
It's a good luck day.
We love Friday the 13th.
Me too. Not
Friday the 13th, January 2023. So with that, I will leave you guys in good hands. Have a great weekend. Have a good week, everybody, until we talk again. Thank you all. We love you. Appreciate you. Signing off from the Justice Revolution.
Okay. Bye, everybody. Have a wonderful weekend. Bye, Erica.
Bye.
See you guys.
James. Good afternoon, everyone. Welcome to the Justice Revolution, brand new show hosted by James the Patriot, who has been tirelessly helping people all over the internet and around the country find remedy to the sticky situations we find ourselves in here. Today, we're going to be talking about how to write a lawsuit from scratch. So we have an open chat. Please ask your questions in the chat, and we will go ahead and do our very best to get them answered. Also, our co-host today is Erica. Erica, who you might have met previously in some of our previous videos, is a critical care nurse who lost her job standing up for truth and not wanting to, have her rights taken, which many of us around the country have had that in the last few years. And she's taken some action back with help from James and many others in learning how to stand up for herself. And that is primarily what this podcast is all about. It's learning how to take the law into your hands and not be subject to the legal system, the lawyers and so forth and so on. You can fight back. You have rights for yourself. So with no further ado, James, nice to see you guys today.
Thank you. Good to see you. Erica, how is life in your beautiful slice of the neighborhood?
Oh, I have a banner existence currently. This whole situation that happened a little over a year ago has opened up my world to an entirely different way of thinking, acting, living, being. And it's bleeding into every area of my life, and my whole world has come alive. So it's been pretty exciting.
That's awesome. That's great to hear. Well, I appreciate you being here. Thanks for co-hosting with me. Yes, thank you, Justice. Appreciate that rousing introduction.
It's true.
Yeah, no, I really do appreciate that. Like Justice says, I do get a lot of people asking questions on Telegram. I get a lot of people sending me direct messages asking for help, and I wish I could help everybody. I really do. Unfortunately, I'm only, I'm a husband, I'm a father. I work full time. As much as I would love to do this full time, I gotta get some remedy to my suits here. So I do the best I can. So please bear with me if I don't answer your question right away. If it takes me a day or two to get back to you, I do travel quite a bit from my day job. So sometimes I'm traveling and I don't have a chance to get there, but I will get back to you. Just let them know. So yeah, like today, what I wanted to go over specifically was a lot of you have been asking in the Telegram group in Affidavits 101, they've been wanting an update on my school district cases that I filed a little over, let's see, it's almost not quite 2 years now. It's been a little over a year. So I filed suit against a local school district here for imposing these COVID mandates on my kids. And we have been going back and forth. There's been a flurry of motions like Dr. Graves talks about. A long story short, it's culminated to the point where I had a lawsuit. Some friends of mine had one as well. It's very similar. Matter of fact, they're good friends of mine. So they took the suit and filed it. The court saw this and they consolidated the two cases into one, which they can do. And we filed an amended complaint. And granted, I'm a lot better now than I was then. Let me put it that way. In reading the law and understanding the law, all sorts of things. And so when I realized the mistake that I made, we petitioned the court after we got an unfavorable ruling from the court to allow us to file a new amended complaint. Well, I got a ruling on everything. There's a number of different motions that we filed. We filed a motion to strike. We filed some other things, and I got a ruling from the court that I just want to share with everyone, which I think is interesting because you're going to like this. Well, let me take it back. So what had happened was when we filed our case and when these motions were filed, if you're litigating in federal court, I just want everybody to know the chances that your case is going to be referred to a magistrate judge is pretty high. So magistrate judges, if any of you have listened to Randy or Brett on Rule of Law Radio, they talk about what a magistrate judge is. And a magistrate judge really kind of handles all of the day-to-day work that's above the grade of a paralegal, but below the grade of a district judge. So there are laws in place under the federal laws that govern the actions of courts that allow a magistrate judge to review and issue what's called a report and recommendation. Okay. So what they do is they review the complaint. They review any motions that are filed either asking the court to dismiss the complaint or whatever the case may be. Then they issue out a report and recommendation. So we had one of those issued a little while ago. Actually, I want to say back in June, if I remember correctly. And it was not very good. Matter of fact, they wanted to dismiss everything. And I filed a response to that report and recommendation, and I lit up the magistrate judge. I lit her up. And I plan on, if this case doesn't go the way that I want it to go, I plan on filing judicial misconduct complaints against both this district judge here, Tina Campbell, and against Cecilia Romero, who's the magistrate judge. But without getting too far off into the weeds, what we got is I got this. Let's see, this was filed on November 1st. I got this report from the district judge who read my opposition, and she read our complaint, and she read everything. And basically what she ended up coming up with here is she's essentially granting their motions to dismiss, but she's also extending us an olive branch in that she's giving us an opportunity till November 23rd to file a motion for leave to amend along with our amended complaint. Okay. So it's right here. Consequently, the court adopts the report and recommendation, denies plaintiff's motion for default, and grants defendant's motion to dismiss. The court allows plaintiffs to file a Rule 15a1 motion requesting leave to amend a complaint, but it must be filed by November 23rd, 2022. Okay. And if you go on and read through this, she goes into, I mean, this is 27 pages. She goes through and talks about all the reasons why, we didn't do what we should have done and this and that and everything else. And I, at first glance and reading this, I was really upset. But this right here is what gives me hope. And I'll tell you guys why. So, so with that, I just wanted to ask Erica or Justice if you guys have any comments or anything you want to share on this. What do you guys read between the lines as you see this?
I think this is great. Like, it's essentially them providing us education on what it is that they're looking for.
Exactly.
That's
exactly.
Beautiful, because we didn't grow up speaking their language.
Exactly.
All of us, like just me in particular, I didn't even get into knowing anything about the law until I knew that something had gone dreadfully wrong and that this shouldn't be able to be happening. Yes. And so as I'm digging into it, then I'm finding out more, but I'm still nowhere near the level of needing to be able to fill out these complaints properly. Right. This is great that they're taking the time to educate you.
So from what I understand, this is one of the benefits to going into court pro se, because Correct. It's their duty. They have to provide you with the proper information that you're missing. And once a lawyer gets involved, you kind of can get shot in the foot, so to speak. Something like that, right, James?
Well, yeah. And their duty, the lawyer's duty is to the public law and to the court system before the duty is to us. Like everyone who talks to me and says, why aren't you getting a lawyer? I'm like, why would I? I'm completely competent to try to figure out my own remedy here. It's just
most people don't know that, right? That is reality, but that actually falls into conspiracy. People, oh no, they're all for us, they're all for the people. So that can play on the conspiracy. But as far as pro se goes legally, am I wrong about that, James? The justice, if you're representing yourself, has to provide you with the remedy that you're missing.
This is it right here. And she spells it out for us, okay? Right. So Rule 15a of the Federal Rules of Civil Procedure, and she puts this right. This is why I'm saying, okay, I'm not a fan of this judge, just so you guys know. I've seen some of her rulings, and a lot of her rulings are very politically biased. Now, set that aside. She also knows and understands that we as pro se litigants are to be held to a much less stringent standard, and they have a duty and an obligation to educate us, just like you said, Erica, on the proper process and procedure. So now they can't write our complaint for us. They can't put facts in our complaint to make the complaint whole. They still have to apply the law and then take the facts as alleged and apply those facts to the law. They still have that obligation and duty. But what I love is, I brought up in my opposition, in which she says right here, within their opposition to the report and recommendations, plaintiff embed a request for leave to amend their amended complaint. So we've already amended our complaint once, and she talks about how district court should freely give leave to amend when justice so requires. Now, Rule 15a allows a judge to deny a motion to amend because of undue delay, bad faith, or dilatory. I can't even say that word.
It looks like dilatory.
Dilatory. I don't know. Dilatory motive on the part of the movement. Repeated failure to cure deficiencies by amendments previously allowed. Undue prejudice on the opposing party by virtue of allowance of the amendment, and futility of the amendment. Okay. So what she's talking about here, this rule is a local court rule. So those of you who are watching, if you're in federal district court in your state, so Erica in Indiana, your court is going to have local court rules. Those rules have to be in compliance with the federal rules of procedure, but they're going to be a supplement to that. Okay. So here, under our local court rules, it states that a party moving for leave to amend, they must attach the proposed amended pleading to a motion requesting this leave. So what does this mean, people? What this means is I now have till November 23rd to file my motion for leave to amend and to file my amended pleading. That's not a lot of time to write up. I basically got to scrap the old lawsuit and write up a new one, and I'll tell you another reason why. Further on down here in this order, the judge says, based on the above, the court orders the following. Plaintiff's claims against the Davis School District individual defendants are dismissed without prejudice. Plaintiff's claims against the Weber defendants are dismissed without prejudice. Plaintiff's First Amendment claims without prejudice. 14th Amendment claims without prejudice. 4th and 13th Amendment claims without prejudice. 9th Amendment claim that one is denied with or dismissed with prejudice.
So will you explain what those mean, with and without prejudice?
Yes. If it says with prejudice, that basically means that no facts alleged can support a cause of action in federal court under this claim. Okay. So now what I have to do is I have to go back and I have to write up a new lawsuit, basically based off of these right here. Our state law claims are dismissed with prejudice. My Utah constitutional claims are dismissed without prejudice. And my request for declaratory injunctive relief is without prejudice. Okay. So taking this, this is what I'm saying is this judge has basically just told me this is what's going to hold water. This won't. Does that make sense? Mm-hmm. So that sometimes I'll get people, they're like, oh my gosh, this judge didn't even read my complaint. They're so stupid and blah, 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 blah. You got to realize that these people are extremely busy. They're adjudicating a number of cases, especially over the last couple of years. The caseload has skyrocketed, for instance. like Alphonse talks about, it's a target-rich environment. Okay. So with that being said, I'm now at square one. Okay. So where do I start? What do I do? Well, what I did after reading this motion, or excuse me, this order, is I sat back and said, okay, now I need to see exactly what would work. And knowing the basis of my suit. So the basis of my suit was you have a political subdivision, a school district, which is a political subdivision of the executive branch that was issuing orders as if it had the same effect as law, right? So just on the surface, I mean, that obviously violates.
So that's what you would refer to color of law, right?
Exactly. Under the color of law. Yes, exactly. So that alone violates the separation of powers doctrine. You know, there's been multiple cases that have said, you know, hey, Congress cannot delegate its lawmaking authority. Congress is specifically enumerated as a lawmaking agency. And this is what I want to really, what I really want people to know and understand. Let me get to the right spot here and I'll show you exactly, is that under our Constitution, okay, under the Constitution, if it is not specifically written, it is prohibited. Okay, so just so everybody knows and understands, if it is not specifically written, it is prohibited. Okay, so let me show you this right here. United States Constitution, Article 1, Section 1. All legislative powers herein granted shall be vested in a Congress of the United States, which shall consist of a Senate and House of Representatives. Okay, pretty simple, right?
Right.
Okay, so what does that exactly? I mean, let me just ask you guys. How do you guys interpret that?
The only ones who can make the law are the people in the Congress. Right.
Okay, so are they? You know, according to that, are they able to say, okay, you know what? I just don't want to come to work today. I'm going to go ahead and just give this authority to Joe Blow over here, who happens to head one of the administrative agencies that's under the executive branch.
No. Nope.
Yeah. Okay. That's what that means. So.
Yep. It doesn't say in there the school districts can make up laws and your local health board can make up laws and.
No. Now the courts have defined over the years that the agencies have every authority to make policies and rules that affect the proper administration of their agency, but that's only for their agency. It's not for individuals such as, you know, us, men and women, and our children. It's not to apply to them in so much that it violates one of their constitutionally secured rights. And if it does, then that individual is afforded an opportunity to petition the redress of that grievance to either have that policy or procedure revoked or grant an exception. This is how this works. Okay. So after I read that report and that order from the judge, and I apologize, I woke up with a little bit of a cold this morning, so if I sound raspy, that's why. So after I read that report from that judge, I sat back and started thinking, I'm like, okay, now I'm back to square one. What do I know? I mean, I know for a fact that I was aggrieved, that we were wronged. My children were harmed. My oldest daughter, she spent her entire 8th grade year in our house. Her entire 8th grade year. I think she went to school for a little bit, but for the most part, she was home. And luckily for me, I mean, I couldn't ask for a better daughter. She's a very resilient person, very outgoing like myself. She makes friends easily. But to say that she wasn't emotionally damaged or physically damaged by that, I'd be lying. My other children who couldn't stand sitting in the house chose to go, but they complained day in and day out, and they were sick more frequently than not because, like as Erica can attest to, they were forced to cover their face and their nose and their mouth the entire time. So as you sit back and think about this, you go, okay, well, I know I was wronged. So exactly how was I wronged and what cause of action can I take? So I sat back and thought, oh, you know what? I wonder, you know, because, you know, I'm always on Telegram looking at other options, looking at what other people post. And I was reminded of a conversation, Erica, that you and I had actually, where I sent you the ruling on that district judge in Florida, the one that ended the mask mandate on transportation. Do you remember that conversation?
Oh, yeah.
Did you read that ruling by chance? I'm curious.
Oh, yeah, very much so. They vacated on 3 different counts specifically, not having the statutory authority. And I don't know, I don't have it right in front of me, but yeah, there was 3 very clear reasons that they gave and then vacated them.
Yeah. So now the next thing that I do is, knowing that, I'm like, okay, well, I want to see that complaint. Since this was a public thing and it was issued publicly, the complaint is available. I don't know if you guys knew this, but every lawsuit that's filed up until there's either a settlement, that dictates whether there's a non-disclosure agreement or not, if that case is not sealed, it's available, and you can find it on the court system.
I didn't know that.
Yep, and so that's available under. So it's here, and I'll show you guys. Let me get to the right spot. It's available on Pacer. Let me just do the entire screen here. So you would go to this website here, pacer.login.uscourts.gov. You'll have to sign up for an account. I obviously already have one. And then you would say, where would you like to go? It goes to the case locator. So what I knew is, because I had a copy of that decision, I knew the case number and I knew the title. So that's all you need is a case number and a title. You can also do an advanced case search where you can search based off of at least one of these is required in here. You can also do based on the date range. There's a few other different things you can do with this. But as long as you have that information, the case number and the title, you can find the case, which I did. So here it is right here. Whoops, let me do this. Let me just share that one instead. Okay. Here it is. This is the case. This is the lawsuit that ended the mask mandate for everybody across the United States. It's right here. So these people, this is the Health Freedom Defense Fund, good organization. They put this together. And now I'm like, okay, as I was reading through this, I go, oh my gosh, this is exactly what I need. This is exactly what I need, because these people here were alleging that this guy who thinks or pretends he's president, the Department of Health and Human Services, and Centers for Disease Control, those are federal, well, some of them are federal agencies. The CDC is a private organization. So
it's an NGO, right?
Yeah, they're an NGO. So anyway, they were named in this suit. Now, this is just a declaratory relief. So they're not asking for damages. They were just asking the court to say, hey, can they do this? And if they can't, end it, which is what happened. So now I can take this and go, okay, I'm going to use this as the basis for my suit. Obviously, I'm not going to copy this word for word because, well, this is for people in federal areas and I'm not in federal. But federal laws apply in all states. You guys knew that, right? You knew that, Erica, right?
I knew that.
Yep. So when I looked at this here, I'm like, okay, so they're challenging the validity of an executive order. Okay, I can do the same thing. Our governor issued an executive order. Our health department issued mandates or whatever that school districts were quote unquote required to follow.
Mm-hmm.
That they then handed down to our kids. Okay. So you can talk all about this stuff here. And as I was reading through this, I go, oh, this is perfect. This is exactly what I need. And this gives me everything that I need in order to be able to take these guys on properly and according to the provisions that the judge laid out in her order. Okay. So this is one Eric and I spent some time yesterday going over her lawsuit. We talked about how do we lay it out properly. What I suggest you guys do is that you find a suit that's already been written and that will do and looks the way that you want it to, and do the best you can to copy and paste it. You don't need to reinvent the wheel here. There's no sense in reinventing the wheel. Right.
We talked about that on the last podcast. So do your best to search something closest to what you're looking to do and use the chat for help. Ask people in there to help guide you, especially brand new people and people that some of this stuff doesn't make sense to, as I am one of those brains. So that's why I'm here. I'm the basic, simple question asker for those who it doesn't really ring with. Some of this language and stuff doesn't ring with some people. Yeah. But don't let that frighten you.
No, don't let it frighten you. I mean, this is a process. Like I said, I wrote that school district lawsuit 2 years ago.
Yeah.
It was the very first one I'd ever written. And I'm so much better now than I was then. Yep. I'm sure you guys can attest to that. I was, I just actually, not even 2 minutes before I jumped on here, I just finished writing a reply brief to another motion to dismiss that we got on another case.
What case was that?
That was the Mike Brown case where he was unlawfully hauled out of the state capitol.
Right. Okay. So, good.
Yep. So as I look at this, I'm like, okay, this is going to fit what I want. So then the next thing I do is like, okay, I want to look at their causes of action. What did they list here as their causes of action?
Right.
So let's go down here. All right. So they're seeking declaratory relief. All right. I don't need to seek declaratory relief now.
Right.
Because we don't still have a standing mask mandate in place. Matter of fact, the Utah legislator implemented a law that prohibits that. So so declaratory relief isn't proper because, we don't need a court to say, well, yeah, what they did in the past was unlawful.
Right.
That doesn't help. But what does help is as I scroll down here and I look at count 1. Okay. Agency action not in accordance with law and in excess of authority, violation of APA. Well, what's APA? Erica, want to take a stab at what APA is?
Something about Administrative Procedurals Act or something.
There you go. Yep, you got it. It's this one right here, 5 U.S.C. 706. Okay. Under the Administrative Procedures Act, a court must hold unlawful and set aside agency action that is in excess of statutory authority or limitations or short of statutory right. Okay. So these agencies were purporting to get their authority from this federal law here. So now, obviously, I want to tie this into state. So there's going to be a state law that's going to be similar to it. But guess what? This is a federal law. It absolutely applies, and I can use it. So here's a new cause of action that wasn't in my original complaint that I can go after them for. Okay, there's the first one. Here's the second one down here. Failure to provide notice and comment. Under the Administrative Procedures Act, they are required to provide notice and to get comments from the public on any new regulations or policies that they want to enforce. They didn't do that. They just did it. Okay, this is how we can overcome that. Okay, count 3, arbitrary and capricious agency action. Oh boy, doesn't that apply? Count 4. Ooh, this is a good one. Unconstitutional delegation of legislative power. Didn't we just talk about this?
Mm-hmm.
Violation of the United States Constitution, Article 1, Section 1, as to the mask mandate. Guess what, folks? Throw your state constitutions in there too. Every single one of them has a provision just like this. 3 separate branches of government that are equal. 3 separate branches of government. And no branch can exercise the authority vested in the other. Okay? So that's going to be one of your counts. That's a cause of action. People don't realize that, but it is. Unconstitutional exercise of legislative power. Violation of the separation of powers doctrine.
Mm-hmm.
Violation of the, oh, wait a minute, what amendment is this? What's X in Roman numerals?
10th Amendment.
It's a 10th Amendment. You guys, the 10th, so first of all, the 9th and 10th Amendments, I just watched a video on this, and this individual, I don't remember her name, but she talks about why those are the two most crucial amendments, and really in the entire Constitution, why they're so important. So, sorry, I just got sidetracked there for a second. Okay, and then here's their prayer for relief. Now, when I found this, I'm like, okay, this is going to be great. I'm going to take this. Now, this is a PDF document. I have a program where I can actually just take this and convert it into a Word document, so I don't have to go through and retype this whole thing. I can just go through and pick and choose what I want to change. And then I can add in some additional causes of action. So I'm also going to add in violation of, what is that, Eric, you have it in your suit, the 360 triple B?
Right, 360 triple B.
Yeah, right.
Yeah, emergency use authorization violations.
Yep. Because again, the masks were only approved under the EUA. So it's a medical device. So you had to be, as a federal right, you were guaranteed the right and privilege of being able to A, have informed consent, and B, the option to refuse. They didn't give us those options. It was either this or nothing. Like with the schools, I don't know where it is in your states you guys are in, but here in Utah, it was you either come to school and wear a mask or you stay home. There was no, oh, I still want to come to school and be able to gain that experience of being able to learn with my peers, but I don't want to have to muzzle myself to do it and force breathing my own air. No.
So I just want to, I think we have two remedies for this person. Etain, I'm not quite sure if that's a male or a female name, Etain. I'm assuming it's a female. I could be wrong. If that's how you say it, apologize if it's not. But as we had Kathleen on, I think her quick form could help this person gain access to her father now. And then what we're doing here, they can turn around now and hold these people accountable for violating her rights. Do you see that as a good thing for her?
I mean, we're still seeing this mask mandate madness in healthcare facilities.
Still.
I mean,
in hospitals.
And they're still requiring the jabs for employment. Can you believe it? With everything that we know about it, I had a young nurse contact me just today. I don't know if she's watching. I told her about it, but she can't get a job because they've changed the requirements in their contracts. Like before, I could just say my contract was breached because you're expecting me to do something that's not in it. Now they're including them in it.
Yeah. Oh my gosh.
Yeah.
I mean, it's it's mind-boggling. These people think they're just above the law. They can just keep getting away with this. You guys probably heard recently. They
are getting away with it.
Yeah.
Well, they think they're getting away with it, and they are for the time being.
Right.
But eventually, I mean, you guys have all heard that, karma, what goes around comes around. Eventually, the chickens are going to come home to roost. Mm-hmm. So, you guys heard recently the New York State Supreme Court issued that New York City's their vaccine policy was unconstitutional, and they had to give all those people their jobs back plus back pay. No, the mayor is still doubling down. He's defying a Supreme Court order. All right. So now here's the question I have is, okay, so what's the remedy there? So if I go to court and I get a judge to issue an order and the people he issued the order against are still refusing to do what the judge is ordering, what's my remedy?
You motion for contempt.
File a motion to show cause.
File a motion for contempt.
Correct. So it's called a motion to show cause why they should not be held in contempt of court. Okay. You guys need to come to court and say, well, hey, this is why we can't follow this order and we have good reason. There's good cause. Well, there's no good cause in this case. You're just refusing to do this because you think you know more than the judges do.
Well, even the lawsuits that are a lot of the people that are winning the lawsuits in their lawsuit, they're asking for proof of harm and proof of this pathogen and proof of, and they are getting dismissed and they're finding relief in these laws because they can't provide the proof. So keep that in mind too. Ask for proof. Ask for evidence, actually, right? That's the correct word.
Yeah, it's evidence. I mean, at the end of the day, and Dr. Graves will say this, and I'm going to, by the way, I'm going to email him and we'll have him on a future episode. I know he would be happy to join us, but Dr. Graves has always said this, and he preaches this throughout his course, the How to Win in Court, is evidence rules, admissible evidence rules. Okay, so you have to be able to prove. I mean, that's the nice thing about civil litigation is the burden of proof. You just have to allege beyond a preponderance that this is what happened. There's no beyond a reasonable doubt. That's the standard at the criminal level. At the civil litigation, it's just a preponderance of evidence, and you can allege all of that stuff. You don't have to present any of that stuff with your initial complaint. Now, I like to give them everything I've got and let them try and weasel their way out of it, like I just did with Mike's case. I just threw it right back in the attorney's face and I said, dude, you're a freaking moron, and you're wasting my time and you're wasting the court's time. Because now, by them filing this motion to dismiss, now we have to file a reply. They're going to file a reply to my reply, and then the court's going to take 3 or 4 months before they issue a ruling on it. When we could have just done away with this earlier. But no, this is how they like to just gum up the system. So, but the good news is that the courts are catching on to this, and they're not going to sit by and just say, hey, this is okay. I've actually seen some rulings from even some magistrate judges where they said, hey, if you guys don't find a way to work this out, I'm going to issue sanctions against you, which is great. So
okay, so here is the grounds for the lawsuit with this person.
Okay. Oh boy.
Yeah, so that's definitely a lawsuit, which I think we're going to wrap the show up with how to begin writing your own lawsuit, right, James?
Yeah.
So what do you want to use this as an example of how you would get started?
Yeah, so you have guardianship. They gave the jab without your consent, okay? So essentially that's, really you'd have to go back and look at, I believe that would constitute a breach of contract. Correct.
And assault, no?
Yeah, it's also assault, yep. Assault with a deadly weapon, yeah.
No, for sure.
Yep. So, battery as well. I'm just I'm thinking out loud here, Erica. How would you handle this one?
The first thing I would do is look through very clearly on what guardianship constitutes, right? Like what every single part of, like I have guardianship of my father and they gave him the jab without my consent. So, yeah, I would look at the specifics of what the guardianship papers say, make sure that they were in possession of the guardianship papers. Is there a way to prove that they knew that the guardianship papers were on file? Because I'm just thinking as a nurse, like, first of all, I would never, I don't know. I just don't do things to people unless they're totally aware. So that's another question that I would ask. Like, was he aware? Did he have the ability to appear to consent on his own? The guardianship paperwork most likely says that he doesn't have the ability to do that. That's why I'm curious to see what specifically is in that paperwork.
Yeah, because generally a guardianship is conveyed by a court. In order for one to have guardianship over another, you've got to go to a court and a judge has to sign off on that. Correct?
Yeah, I'm not sure what that whole process looks like, but yeah, I would check into that first and then just start seeing where the violations are. That's that's the whole thing of everything that I'm doing lately. I'm learning how it's supposed to be, whatever the situation. I'm learning what's supposed to be. And then anything that's outside of what's supposed to be, you find out what the violation of it is.
Yeah. Yeah, it's just, and Eric and I have had this conversation a number of times. It's just take out a pen and paper, write it down. You know, what you want to do is your lawsuit is your story. So you're telling a story of who did what to when and why, why that violated the law. It's pretty simple. You just got to write that down, and you want to write it in a way where it makes sense. So the first thing that you want to do is just collect your thoughts. Go, okay, what happened? This is what happened. Okay, who was involved? Write that down. Who was involved? Once you have the what and the who, then you can add, okay, well, where did this happen? When did this happen? Now that I have that stuff, okay, now I can sit back and go, okay, now I need to understand, okay, what exactly happened? Were my federally protected rights, were those violated? Because for me, guys, this is just me. Take it for what it's worth. I feel like these state courts are a complete waste of time. That's just me. These state judges are, Dr. Graves will probably disagree with me, and that's okay. He's entitled to his opinion there. He's litigated in Florida and other cases in other states. But where I'm at here, I have not seen any judge that adheres to the rule of law here. And it doesn't matter if it's at the district court on up to the Supreme Court. I'm not seeing that. That's just what I'm seeing here. So, yeah.
So you skip it altogether, you're saying, and you go straight to the federal court.
I just go straight to the federal court because I can take any action and say, yes, that violated my constitutionally secured right. Guys, the 14th Amendment, it's such a broad, sweeping amendment. One of the things I love about it, and Erica knows this, is you have a 14th Amendment protected right to refuse unwanted medical treatments. That's a 14th protected right. 14th Amendment protected right.
Okay, so write that down, Etain, the 14th Amendment. Research that. And I'm going to put this in here.
The 14th Amendment in the case of guardianship would apply to the guardian on behalf of.
Yes.
That's where you get it because he has dementia.
Right.
And he can't give informed consent anyway. So for any procedure that they're conducting on him, I'm talking if it's a central line placement, if it's a procedure, if it's anything, they have to, the doctors always go outside of the room and call the family member or whatever it is. Yeah.
Yep. Whoever the legal guardian is, it's in charge of making those decisions. Exactly.
Right. Well, and if you've already been to court, which it shows that you have, I mean, it's clearly some major violations in here. Yeah. So this is what's happening is that we don't know how, which is the whole reason James wanted to do this podcast. We, as a people, have been hidden from our rights for a long time, and we don't know how to stand up without hiring a very expensive attorney, which most people don't have that in their budget to do, as they're trying to save money to retire and everything else. And that's the purpose of this. Even if you learn one thing today, then that's great, and it can be overwhelming. I can certainly attest to that. But don't quit and don't get afraid. Go to Affidavits 101, research Dr. Graves, How to Win in Court, and research Alphonse Fagiola's website, which is
I'm not sure that he maintains that website.
Okay. Well, he's got a Telegram chat. Anyway, go into our Affidavits 101, ask questions, and that's what we're there to constantly try and point people to, get help. And sometimes no one's available to answer questions, but just keep trying, don't quit. And that's why I think these violations in this particular case is happening, because they know that you have to take them to court, and it's a huge expense, and it's a huge amount of knowledge and time that people don't have. So, if you're lucky enough to find a group like this, find a guy like James, stick to it. And Erica, she's been doing amazing on her own, attaining amazing knowledge and helping people.
Well, one of the biggest tips too that I found, like with going from having zero concept of what to do to remedy a situation to being able to start. First of all, taking the How to Win in Court course was really important for me, because it took every nebulous sort of all over the place thought that I had about how it all works and simplified it in a way that goes, okay, now I know what's going on and I can totally do this. Like, everybody thinks that you need to have a lawyer to represent you. But that takes away so much of your power. Their duty is not to help you. Their duty is to the courts and to the public law. And if helping you violates either of those two things, they're not going to do it. So it's actually kind of completely bizarre to even think about getting a lawyer. So that was the first thing. And then the second thing is, when you go onto your court's websites, like they show you, if you're representing yourself pro se, they show you, they have specific sections for you to show what forms you're going to need. Like your entire complaint, the entire lawsuit complaint is in a drop-down box that has fillable little areas that tell you what you need to address. So you don't have to just come up with it from your head and know what's in there. You do have to figure out what laws they're in violation of. But honestly, that's something that we should all be doing, right? We should all know what the laws are, and everything that's in the Constitution. Those aren't laws for us. Those are laws to govern the people who are supposed to do one thing and one thing only, which is protect our rights. And they're not doing that.
They're not doing a very good job of it, are they?
We can't hold them accountable if we don't know what they're supposed to be doing. So this is all returning us to a place of, you need to find out what the law. It's not that difficult. There's not that many to learn. And in your gut, you know when you've been wronged on something. It just takes a little bit of research to try to figure out what the name of it is so that you can put it in front of a judge.
Yeah. Right. Yeah. And that's, you know, Erica, you hit the nail on the head. I mean, and gosh, how long have we been working together on your suit? Geez, it's been months.
It's been a year, but you know, I'm building the airplane as I'm flying it. And that's what I want to encourage everybody else to know too. I'm not an expert. James is not an expert. None of us is experts. We're all just learning as we go, because that's how important it is to fight and to stand up for the truth on stuff. The people who are trying to keep us away from this knowledge are part of the problem. Like we can't just, you know, we're so busy taking care of our families. And that's why it's taken so long too, is because I work on this when I have a chance to. And sometimes I don't have a chance to, because I'm homeschooling. I'm working on a business. I'm like I'm homesteading. I'm like, I've got sourdough starter. I just came from upstairs right before I came in here. I'm like, okay, you know, like,
we have a million things going on.
I got things going on, and we all do. But this is so important to stand in the truth of who we are. And once we do it, and we are all doing it, then they should be afraid. If they are not living according to the rules that they're supposed to be living by, then we're going to have to come after them.
Yeah. You guys, there's something that's important. And then I just want to say this one thing. And then when I'm done with this, Justice, if you put up that question from CC here in a second, the important thing to remember, people, is we often think that the Constitution is what tells us what our rights are. And that is so wrong.
Say that again, James.
We often think that the Constitution is what tells us what our rights are.
Okay.
And that is not true.
Right.
Okay? We have rights that are not even enumerated in the Constitution. And this is what the founders knew, is that, hey, there are certain things that we know we have a right to do that the government can't interfere with. I have a right to choose what I want to eat for lunch. I have a right to hang out with whoever I want to hang out with. What I don't have a right to do is I don't have a right to do something that's going to harm my neighbor or anyone else for that matter. That's not a protected right. Okay. Yeah. CC's talking about it. It's often known as the natural law or the common law. Okay. Common law, really the easiest way to explain this is common freaking sense.
Yeah.
We're all born with it. You know, some people over time just decide to kick it to the curb and do whatever they want. But common law is the common sense. It's the golden rule. Do unto others as you'd have others do unto you. Okay. So when you look at the Constitution, the founders are like, hey, we need to write things down to tell the government what it can and cannot do. So the powers that are listed under each one of those sections in the Constitution, those are the enumerated powers. If it's not written in the Constitution, the government is prohibited from doing it. So don't get me started on all of these government agencies that are existing today that are nowhere to be found in the Constitution. I mean, this is a massive problem that's been compounding over almost 200 years now. So, you know, this country was operating flawlessly for about the first almost 100 years. And then after that, it started to kind of tumble down, and slowly but surely, precious things that were enumerated in the Constitution have slowly been taken out. But the best way I can explain it is the way that the light bulb went off in my head. I was listening to a lecture series from the John Birch Society. I turned Erica onto that. And the gentleman said, you know, the way our federal government works today is a lot like if you were to take your car into a mechanic and you say, hey, I need new brakes. My brakes are not working. I need my brakes fixed. And the mechanic says, okay, come back in a few days. I'll have it done. So you come back in a few days and you find out that not only are your brakes not done, instead of doing the brakes, they decided to change out your wheels and tires, tint your windows, and they put on some new windshield wipers for you. Oh, and then he hands you the bill. And you're just like, dude, wait a second. I didn't ask you to do this. And his response is, well, you never said I couldn't.
Yeah.
That's how our federal government operates today. They operate under the Constitution doesn't say we can't. Well, hold on a second. It tells you exactly what you can do. And if it's not written there, you are expressly prohibited from doing it. This is what we need to understand. This is the basic concept we need to get back to. So we throw that question up on the screen from CC about Title 42. So CC, this is a great question. Title 42, 1983. This is a statute that was enacted by Congress right after the Civil War, which gives you a cause of action to sue a state actor for violating your rights under the color of law. Okay. State actor thing does get a little confusing. If you want to file against a university, this is the cause of action to use. Matter of fact, there's also individuals that are federal actors that can be sued under this statute as well. That's what's known as a Bivens claim. And where that comes from is there was a lawsuit that was filed by, I can't remember his first name, but it was Bivens, alleging that these federal actors violated his federally secured rights. The courts agreed, and they said, okay, yes, you can do that under the statute, even though the statute talks about state actors under the color of state law. So absolutely, the federal court is where you want to go. This is my go-to cause of action because it's broad and sweeping, and it encompasses a lot of your constitutionally protected rights.
And it even works for private companies too, right?
Yep.
Like everyone was saying, well, you know, your employer has the right to do whatever they want to do. Like if
they do not.
rubber chicken on your head, then you wear a rubber chicken on your head. Like,
well, let me ask you, if wearing a rubber chicken on your head, is that going to harm you?
Right.
Is that going to violate any of your constitutionally secured rights? It'll make you look like an idiot.
Right.
Well, and if it was in my contract to do so when I signed, and I knew that was an expectation of my job, but if they all of a sudden, made it that way, then
let's just talk about that real quick, though, Erica. So if I give you an offer of employment in contract, and I say, okay, Erica, I will pay you X amount of dollars, and as a result of that, you need to go out and you need to rob 3 banks every month. Okay, are you going to sign that contract?
Probably not.
Okay, why not?
Because
you might get some takers nowadays.
Law.
Yeah, right. You can't rob a bank. Okay, we just know that. So contracts, even if this is the argument I get all the time. Well, if the employer requires it as part of their contract and you agree to it, okay. The employer cannot require any unlawful activity in a contract and call it a contract supersede. No, that's not how it works.
Right.
It's an unlawful contract. It's a void contract. It doesn't work that way.
Right. And often the contracts are, it's almost like a sleight of hand, right? Because no one reads these things. You go through signing up on a website and you get 4 pages of this with an I agree or you can't get in. That's all a trick.
Yep.
So it's done with deception.
So with all of these hospitals now, including this bit of a requirement to inject yourself with an unknown harmful experimental substance for the condition of your employment, like, what can, other than go someplace else? That's my whole thing right now. And that's part of what I'm doing with my life right now is finding remedy to offer a parallel society of sorts to having to deal within the public and these people who are combining in a racketeering scheme of epic proportions with a corrupt government.
Yeah.
We have to withdraw from them. We can't give them our labors. We can't give them our effort and our treasures and our times and our talent if these employers are requiring this of us. But what remedy, can we just start sending notices of liability to these employers that what they're requiring as part of their, just sending an informal, I don't know, how would you approach that?
That's what I would do first. I mean, rather than just going straight and suing them. Now, often I kind of take the approach of okay, hey, if you wronged me, I'm just going to sue you. Okay. I'm beyond that point. But,
right. Well, this is what I didn't mean to interrupt. Sorry.
You're fine.
This is what we had talked about when we had Kathleen on, and that's basically what she's doing. And what she's doing is she's asking for evidence. And she's asking for if they're intending to harm her or, usurp her rights and all these things. And that is helping a lot of people because instead of the burden of proof is on them. Prove that this is necessary. Prove that there's a danger. Prove that I'm a danger. Prove the safety. So it's working amazingly.
Well, and I would take that approach, right? So let's take your friend, Erica, you're talking to who's struggling to find a job because of this situation. Well, if she interviews somewhere, and I'm assuming it's a she, I apologize.
Yeah.
So she has an interview and she asks the questions like, well, is this a requirement as a result of my employment here? And they say yes. And say, okay, well, I just have, here's where I'm at. And this is kind of the side part of it is I would send a notice of liability or kind of like a tort letter, right? It's a notice of liability. It says, hey, I'm willing to agree to this as long as you accept full liability for any and all harm or damage or anything that I will suffer from this or I could suffer from this. I mean, you're just going to make this liability so massive that there's no way on this green earth that they're ever going to agree to this. Now, they just might say, well, we'll hire somebody else.
Right.
The reality of the situation is, look at the numbers for the military. Okay. Ever since the mandate for the military recruiting numbers are down double-digit percentages.
Right. For nurses, the same thing. Still, every day, I get offers every day. $5,000 a week. Please come be a nurse, please. They're so desperate. These agencies they're having a hard time staffing right now. Yeah. They need to make it even harder. Nurses like this girl that just reached out to me, we need to just withdraw until they stop being stupid and keep sending them the message that I'm not satisfied with this offer because of this. Instead of just being quiet and shrinking away, every single recruiter that sends me a notice, I send back, just to get the word out there so that they can pass that to their higher ups and that they can pass that to their higher ups. So eventually they're telling these people, we can't find any workers because they don't want to put up with this garbage.
Yeah. It's just a contract, right? So if their offer is, well, we're going to offer you employment, but you've got to do this, you can come back and say, well, I will accept your employment, but I don't want to do this. So in lieu of this, here's what I would suggest. Right. You just go back and forth, and this is what Kathleen talks about. But to further this on, I would take the administrative approach first. I would send those letters. I go back and forth. I want evidence. I want them writing, no, this is required. We require this. Because if I have it in writing, oh, bing, gotcha, that'll work. Now I have it
request for it in writing.
Mm-hmm. Exactly.
That's a great idea.
Now I have it from you in writing that you are stating that you are violating federal law. Boom, I've got you. Right. Now I can file a lawsuit and I can say, you denied me express employment after I said I was unwilling to do this, and I have a right under Title 21, 360 BBB to refuse this. Because it's not a fully, there's somebody recently argued in court that the Comirnaty one that's available is the same. No, it's not. It's not the same thing. Mm-hmm. And the court that came back and said, no, it's not the same thing.
It's not even available in America.
Nope, not even close. So that's the approach that I would take. But just to wrap this up, we're coming up on an hour. Actually, we're a little over an hour. I wanted to keep these podcasts or whatever we're calling these things. What are we calling these?
People call them podcasts now, but that's typically audio. We broadcast.
Yeah, broadcast. Sure. All right, we'll call it that. I wanted to keep this to just about an hour, just so you guys can, if you're listening to your car or you're watching this, you can get on with your day. But I wanted to give you some action items, things you can do.
Right.
So step one, is you must, and this is a must, anybody who reaches out to me and asks for my help, I'm happy to do it, but you must have a subscription to howtowincourt.com. It's $250. I know sometimes it's a lot of money to some people. Do what you can to scrounge up the money. As Erica will contest, it's a must-have.
Okay? And James is not making money from this. He's recommending it.
I am not. No,
just so you know.
Yeah, I'm not making money on this. Now, in full disclosure, so if you click on the link that's in Affidavits 101, I do get a small referral fee, but it's very small. Okay, and I don't do that because Dr. Graves says, "Hey, you're sending people my way. I want to thank you." I said, "That's up to you, Dr. Graves. If that's what you want to do, then that's fine."
Well, you should be making money. I might make a donation site for you.
Yeah, I don't.
I'm like James manager.
I'm good.
James, I wanted there was a question that Cece just had that I saw popped up that I think is really important to answer that about, the hospital saying that it was private property.
Oh, yeah.
Saying that they could force a mask because it's private property.
No, it's not private property. Sorry.
No, if they receive any single dollars from the government, which you bet your bippy they do,
yes, they do.
Then they have given over any private status that they might have and entered into the public. Yep. And you are protected as a public person out there in the world.
I think even one step further, if they are an entity, even if they are private, but they are servicing the public, they still cannot force harm upon.
That's true too. Yeah.
That falls under the Civil Rights Act of 1964. Yep.
But the double whammy is collecting a few bucks from the government, null and voids it all. Absolutely.
Yeah. See, this is what, the states love to throw out their sovereignty. Well, we're a sovereign state, right? And under the 11th Amendment, we're protected from suits in the federal court. Well, yes, but you took federal money. And there's provisions with that. The courts have long held if you take money from the federal government, you're waiving your sovereignty status.
Right.
So,
okay. Well, yep.
Good catch, Erica. So,
okay. All right. So step number 2.
So step number 1, how to win in court. Step number 2, research. Jump onto Google. Jump into the Telegram groups. Ask your questions. If you're unsure of what cause of action you have, ask the question in the Telegram group. Say, hey, this is what happened to me. What's my cause of action here? What action can I take? And you're going to get answers. Once you have a cause of action, you can jump onto Google and you can search sample lawsuits for, and if it's a deprivation of rights, just type deprivation of rights. Deprivation of civil rights. Okay, that's what you need to do. Now, I'm not a smart enough guy to just write stuff up off the top of my head. Sometimes I am when I'm writing my reply briefs, but when I'm writing my actual lawsuits, I need a template. I need something to follow. And there's a lot of smart people in this world that have done this long before me. Okay, so search online. You're going to find a whole bunch of options. Look into Google. Google's the best place, and I hate to send people there for who they are, but
you can do Yandex or
whatever.
Brave
whatever
or something.
Okay, and then once you have two or three samples, also too, let me throw this out there as well. So Alphonse has, so Alphonse and my buddy is Steve Emerson down in Florida. Steve has a friend who put American jurisprudence on a couple of CD discs, along with a number of there's hundreds of legal documents, complaints. There's a complaint library. I search that complaint library all the time.
I think Alphonse posted that on our Telegram.
He did, yeah.
So, zip drives. Yeah.
I'll go ahead and put it back in the chat because we have it in our documents file. So for those of you watching.
I'm trying to see if it's right here. So this is the CD right here. This is one of them. So they only work on a Microsoft Windows 64-bit, I want to say, system. I mean, it's really antiquated, but you'll have access to American jurisprudence. That is crucial because American jurisprudence, what that is that's a collection of case law that is authoritative, meaning if this is the situation, this is what must be followed. So in addition to doing your research on Google, if you have access to that, you can search that. You can get access to that by sending Alphonse a message directly and say, hey, how do I get my hands on this American jurisprudence? He will email it or he'll direct message you back the address to send. I can't remember how much it is. I want to say it's like 50 or 60 bucks. I don't remember. And then the guy will mail them to you in the mail. So once you have done your research, step number 3, start writing up your lawsuit. Get a draft. Get a draft written up. And once you have the draft written up, post it in the affidavits group, post it in Alphonse's group, post it in Brandon's group, the Big Sib Law, and let people just rip it to shreds. Erica knows this all too well, right? What are some of the things that they've said?
I love it though. Yeah.
So what have they said so far?
Oh, let me see here. There was some issues with my jurisdiction.
Good.
Yeah, there was issues with jurisdiction. I needed to be a little bit more specific on my parties. And the overall thing that was really concerning for me was that saying that my facts were more like opinions.
Yeah.
And then, it's the court only understands the language from higher courts. Speak through them. Don't use your own words. So, and that's hard because I only know what I know. So,
yeah. And that can be difficult. Going back to the school district lawsuit that I shared that judge's order on, that was the first one I'd ever written. And when I wrote that, I was writing down the facts as I knew them. Well, I didn't realize that they were more of my opinion than it was an actual fact, right? So, for example, if I say, well, I don't have a contract with you. I've never had a contract with you. Okay. That's an opinion. That's not a fact. So the way you change that, you say, is I am not in receipt of any document that would allege that you and I have an agreement together. Right?
Yeah.
I don't have it. That's a fact. Okay. So Etain, would I do 2 separate suits, one for me and one for dad? No, you would just do one suit. You actually don't have a cause of action. Your dad does. but you as the guardian would be his representative. You can speak for him. Now, research your laws. I don't remember what state you said you're in if you're in New York.
Yeah, New York.
Research your state laws regarding being able to sue on behalf of someone who is not physically capable of doing it themselves. There are rules on that under the federal rules of civil procedure, so look at those. We'll talk about that.
James?
Yes.
You had mentioned your as a dependent under 18 or so forth is considered your property. Would that be the same in a situation where you have guardianship?
So under the common law, they're considered your property, but in our court system, that's not going to fly.
Okay.
So you can't say, well, these kids are my property. No, because we know I can't physically own another human being. I mean, that's barred by the 13th Amendment. We know that. So, but you as their parent, you have parental rights. And as a guardian for them, you have rights to be able to, where they can't physically or mentally stand up for themselves because they're not quite there yet. They're not developed enough to do it on their own. You can step in as a parent and say, hey, school district, you violated my child's rights. And as a result, you're liable to me, a parent, for doing so. So that's the way you would do that. You'd still refer to them as your children. Most federal courts, though, when you're suing on behalf of your children, you're going to say for on behalf of, and you're going to write your kids' initials. Because since they're under the age of 18, they're protected by the privacy laws. You can't put their names in there. So, okay.
Okay.
So with that, you guys, we're a little more than an hour. Any final thoughts? Anything you guys want to throw in, Erica or Justice?
Mine is just, it's a repeat, is don't be afraid, stick to it. Some of us learn quickly, some of us don't. And I actually wouldn't even be part of this broadcast, except people always message me and say, thank you for asking those basic questions, because that's where my head is, you know? So I just like to be there to do that for people. So don't get intimidated. Have patience with yourself, ask lots of questions, and whatever you do, don't quit. That's what I say, because that's why we're in the pickle we're in.
Yeah. Yeah. Well, I mean, you're involved in a federal suit right now too. I mean, it's involving
James is helping me.
Yep. You're involved in involving your property. So if we just sit back and let these people steamroll us, they're going to do it to someone else. They don't.
I have one other suggestion too, just to make it doable, because take a good inventory of how you spend your time. Generally, if you say that you don't have time to do something like this, look at your screen time on your phone and try to determine how much of that was spent on learning something that's going to positively benefit your life. Mm-hmm. And then what I've been doing, and my son that I'm homeschooling is, we enrolled in the Hillsdale College has a bunch of free courses, and they're very easy to understand. Like he's 13 years old and he can totally understand everything. It just breaks it down. So make a goal for yourself. It gives you progress reports, even if you're only able to work on your courses for 5 minutes a week, or I'm sure you have more time to spend than that, but just make a real dedicated effort to be spending some time learning something that's going to benefit you.
Right. And so much of this is just auditory. So, one of the things that I've been doing in the last year is I put in the headphones and I'll, whether it's rake the leaves or do the garden or vacuum the floor, I'm always trying to get good input and learn something, rather than music or entertainment. That's a great suggestion. And
there's not a single free minute of my life where I'm not learning something.
Right. I'm the same way.
Yeah, all the time. If I'm cooking noodles, I'm learning, I've got something open there or I'm discussing something of importance or drafting something or,
Yeah.
Right. There's an expression.
I'm always looking for anything, any lectures on the law, any lectures on the process and how to do things. I love listening to Randy and Brett on the rule of law. If you're on the Telegram under the Law Society, there's an individual who posts all of their past episodes. They usually have episodes on Thursdays and Fridays. And you can listen to them on Telegram, commercial free. They've got a lot of good stuff in there. A lot of good stuff. Randy's been doing this for over 30 something years. So he takes a little bit of a different approach than I do, but you're going to pick up a lot of good gems, a lot of good strategies for how to respond to things. In our next episode, I'm going to talk about what to do after you've gotten your lawsuit is written, and talk about what to expect when you file it. What is the other side going to throw at you? How do you write a reply brief? How do you study for stuff like that? So we're going to talk about that on the next episode. But
so, James, do most lawsuits have to have affidavits accompany them, correct?
So yes and no. Okay. When I say for us, yes. Okay. You're going to want to submit a supporting affidavit that states that everything that I have said in here is the truth, the whole truth, nothing but the truth, based on my personal information. Okay. My personal knowledge. The reason why is now that can be admitted as evidence because the other side can cross-examine you. So there's been a myth that affidavits cannot be admitted as evidence. And that's only true if it's a third-party affidavit. So, for example, if I file a lawsuit and I submit my affidavit and then Erica submits an affidavit supporting my lawsuit, her affidavit is hearsay until she's able to be deposed by the other side.
Okay. So
this is the way our adversarial system of justice works is both sides have got to be given an option to rebut any claims that are made anywhere that they're made.
Okay. So in the process, I just want to lead people. If you post your lawsuit or questions, if you feel like this is a requirement for your lawsuit to have an affidavit, we've got the steps up, affidavits101.com.
Yep.
You can go there, watch the videos, and learn everything about actually getting your affidavit written up as well. Yes. So, we've already done videos on that, just so you know.
Yep. Yeah. And like I said, we're happy to, once you get your draft done, your draft of your lawsuit, your draft of your affidavit, post it. We'll review it and we'll say, yeah, hey, you're missing this, or you should add this, or why don't you change the verbiage in your affidavit from, like in some people, like if you're having, this happens all the time. How many times do we get calls from a debt collector who bought some debt off the internet, right? So I send a rebuttal letter to them and say, hey, it's not now, nor has it ever been my intention to avoid paying a lawful debt that I may owe. But in order for me to determine that, I'm going to need you to provide verification and validation.
Right.
And every time I do that, these people, I never hear from them again. I got a letter from the Social Security Administration. They said, hey, we overpaid you guys because my nephew that lives with us was receiving Social Security. They said, hey, we overpaid you $10,000. You need to pay us back. And I said, like crap, I am. I replied back to them and said, you're going to need to provide validation and verification of this supposed accounting error. It's been 2.5 months. I've heard nothing from them.
Yeah. Yeah.
So
they're just,
well, it is a government agency. They're not hiring.
They're operating at the peak of their performance. I get
right.
it.
They hire the best.
Yeah. Absolutely.
That's right. Well, hey, you guys, thanks so much. Erica, thanks for being on. Thanks for being my co-host. Justice, thanks for organizing this. We probably won't be doing another broadcast for a couple weeks. So I'm going to be traveling next week. So the next broadcast will probably